So that's why asset protection is part of that 3 legs, making that stool stand up and not top.
Welcome to a brand new episode of the M&A Mastermind Podcast, where we dive deep into the latest trends and strategies to take your firm to the next level.
Hello, everyone. Welcome to another episode of the M&A Mastermind Podcast, your go-to source for all the latest in industry trends and topics to help you level up your M&A practice. I am excited to welcome back Joe Strazzeri for the third time. We have a three episode series, and it's been first 2 have been great conversations. We talked about the business conundrum, advanced planning. We talked about timing, combining, and sequencing with those strategies and goals. And today we're talking about the asset protection continuum. A lot of long words there, easy for me to say. So Joe, welcome back to the show. Glad to have you again. How does today's subject, the asset protection, fit into advanced planning and the conversations that we've had in our previous episodes?
Whenever you're touching a client and you're touching their assets and you're looking at a major event like the sale of a business, sale of property, somebody's death, gifting away assets, whatever it is, buying a new business, you touch income tax planning, which includes capital gain, ordinary income, etc. Mm-hmm. You touch an eventual or future estate tax. And you also touch asset protection. Most people try to attack one slice, and in doing so, affect the rest, and the client doesn't know that they got affected. Mm-hmm. So if you sat down, Nick, and you told a client, I can save you 20% of the tax on sale, of the tax that will be paid. And I can make sure that nobody can take it away from you through a lawsuit. Mm-hmm. Or I can save 50% of the tax, but if you get sued, you can have it all taken away. Nick, you might choose differently, but each client would choose differently. Mm-hmm. But they would be thrilled to know you asked because nobody else trying to give advice did ask them. And they'll say, instead of yeah, they'll say, I'm sorry, say that again. And in their head, they're saying, the last 3 people that talked to me did not talk to me about it affecting whether it can be taken away from me or not. They only talked about saving the tax. Wait a minute, there's another variable. Business owners are like junkyard dogs. They can smell you across the dust and the dirt, the burning oil, the dripping oil, the exhaust fumes, then across the street with the cars going by. They sense you all the way over there, and they sense who you are and what you do. And as soon as they realize that they weren't told the whole story, they're done with you. So if you're the advisor talking to them about this is going to affect 3 different things, your income tax planning now and how you have the asset, how you pay taxes on it in the future, which deals with your net cash flow, your eventual estate tax that your family will pay, and the asset protection on how somebody might take it away from you because they're now selling their biggest thing, worth everything to them. They've got no way to remake it. You win as the M&A advisor because you're talking about more than the last 3 did. So that's why asset protection is part of that 3 legs, making that stool stand up and not topple over.
This episode of the M&A Mastermind Podcast is brought to you by Cornerstone International Alliance, a global partnership of M&A firms focused on the lower middle market. With CAA, you get access to collaboration, expertise, a global presence, and much more, all to help take your firm to the next level. Interested in becoming a member? Visit cornerstoneia.com/new member.
And you can say that's the one that you just said isn't talked about and brought up. And how often does that come up down the road over the course of selling and post-sale, if it does?
Well, remember, the business owner is very excited. They're basically doing the math of what's the number I need.
Yep.
And unfortunately, they don't realize that it's not just about the gross number. It's about the net number. As we talked about in the other episodes, every asset that I own, that you own, Nick, that the clients own, that your audience owns, has 4 motives. 1, take care of my family with the profit that it generates. 2, have extra profit to buy passive income assets so I grow. Number 3, the asset itself should grow in value. And number 4, it should be protected from taxes and lawsuits. Now, each asset does better or worse on each of those 4 scales. Some assets suck at one of them. I was telling you earlier, I'm buying a big asset, I'm buying a boat. I will tell you, it's not going to generate profit. It's not going to generate extra to buy more. It is going to take care of me. I'm going to buy it for less than it's worth so I can argue it might grow in value. Let's face it, it's a hole in the water. And I have all sorts of insurance to protect it. That means my other assets have to outperform. If you explain that concept to a business owner, they're going to say, wait a minute, I never thought about all that. And the last one, protection from the biggest creditor, the IRS, and protection from lawsuits. If I lost this asset, my life would end. It's my biggest one. So am I causing myself to possibly lose because the buyer might sue me? Because there might be a lawsuit dealing with the business that in the agreement I still have liability for, although I no longer have the business to pay for it? How long is that liability for? How much am I liable for dollar-wise on it? Or did my wife, who passed me up today, I've got a heavy foot. My wife passed me on the freeway today. If she, God forbid she got in an accident, she was fine, thank God, but she got into an accident with a surgeon and he lost his hand and he sued for $20 million. My car insurance and my umbrella would cover 10. They come after me for the other 10. Should I protect my assets beyond the business issues? So that's why asset protection blends in, because you're touching it too. And if you're the M&A advisor that's talking about what's valuable to the family long-term, yes, the bigger number, but more importantly, the cash flow I get from the number, serving those 4 motives, which includes protecting me from losing the damn thing.
What are the different types of asset protection?
Well, there's structure, and then there's jurisdiction. So I happen to live in California. We believe anybody that owns real estate or business should pay other people part of their value. That's just a moral thing that California believes in. So we make workers' rights and tenants' rights and other people's rights to have less money more powerful than those who own real estate or own businesses. As opposed to Nevada or Wyoming, who values the owner of the property and the owner of the business more than the individual that hasn't done it. So their laws are set up differently. So could I, as a California resident, borrow the laws of another state to protect my assets? The answer is yes. So I have a Nevada and I have a Wyoming trust that's seasoned over there. In Nevada, it's for 2 years. In Wyoming, it's 120 days. That if it sits there past that and somebody sues me, they can't get it. In Nevada, they protect against child support. In Wyoming, they don't. It's a moral judgment. Wyoming has the only LLC laws that allows me to own things anonymously through the LLC that nobody can ever find. So I wouldn't put my house in it that I own now or my property now, but I would buy new things. So that's jurisdiction. Then there's the type of entities. So we have corporations or LLCs or partnerships that can make it to where in this vessel, if there's an explosion in the vessel, it stays in the vessel. Or can make it, if there's an explosion in that one over there, and they come at me and they try to get this, there's a poison pill with it. But then there's also insurance. Like I mentioned, my umbrella policy. Disability and life insurance protects them against something terrible. Property and casualty. Then there's types of trust, domestic asset protection trust and offshore ones. You got to be careful when you're mixing asset protection with income tax planning because they don't mix well. And then there's, of course, equity stripping, retirement trusts, and offshore planning, though that's become more difficult and not necessarily as needed because we've got some states that have increased their asset protection laws. Remember, if I own something in my name or in my revocable living trust and somebody sues me, they can get it. If I make it owned by another taxpayer ID number, then if it's in trouble itself, and it doesn't get to me if I follow it by formalities. If I have multiple buckets, they're spread out. And to be even better protected, If I have another trust that's a taxpayer ID number that owns it, I don't. So if you sue me, you don't get it. Now, if it owns an asset that's screwed up and it's sued amongst itself, it needs protections too. Oddly, when you're doing income tax planning for the sale of a business or estate tax planning, you're doing those same types of things so it can be done together. And most clients don't know they're being done together and don't know the end result because everybody was concentrated on this one event moment as opposed to the effect of the event. No client just wants the biggest number. Every client wants the largest amount of cash flow from it afterwards because it's a cash flow game. We as advisors think it's about solving for the number. It's what does the number do? And the number takes care of my family through cash flow. Yes, I care about a bigger number, but I want that bigger number to produce more cash flow. That's its job. Its job is to take care of me and have extra to buy more stuff and grow in value. All of those depend on my structure because I can do structures that freeze in value that don't, or give cash flow to other people. That's not a good idea because I worked hard. I want to take care of all those people, but I want to make sure my wife's taken care of first. Oh, and by the way, me.
And it's protected, right?
Yes, sir.
Who are potential claimants and creditors that could go after this stuff?
Sure. So whenever I sell something, real estate, boat, business, the person that bought it from me has certain rights to sue me based on the agreement and based on state laws. Now, if I hid something, I don't care what the agreements say. I don't care which state you're in. If I hid something on purpose, they get to come after me for it. The question is, did I not know or should I have known? If I should have known, it's kind of like you sell the house and you paint over the crack. You made a patent defect into a latent defect. It's hidden. The act of painting it over is going to get me in trouble later. But if the crack was there and I fully disclosed and they bought off on the crack, I got no more liability. But then you might argue, but then I'm going to get $10,000 left for the house. I'd rather get $10,000 less for the house than can be sued for $500,000 later. And that's the owner's choice. So there's the possibility of somebody that bought something from me suing me. In the agreement, there's probably some language that limits the amount of time they have to sue me or the value they can sue me for, or it's silent to it and it's forever. Even with that language, if I didn't disclose, if I hid something, the lot time is longer. It's a year from when they could have or should have found it. Secondly, what if somebody sues the business for an act that I did and the buyer says, hey, I didn't know about that and that was him. Am I allowed to be included in that outside lawsuit? Like in California, a PAGA suit, where employees can sue on behalf of all employees for the last 3 years for not getting their lunch break or for not bending over too often or not getting bonus time, not getting their proper overtime pay, whatever it is. And in California, we're a state that believes in employees' rights, not employers. So we let them act like the attorney general with their powers to come sue me. So that's kind of hard. The third type of creditor is my creditor that are developed from assets. I have an apartment complex. Somebody falls off the balcony because the rail was loose. Could I have never known about it? Or did somebody tell me about it last month and I hired somebody that doesn't know how to do it to fix it? And I knew it was wrong and the person got hurt. My insurance won't even cover me for that because I caused the problem. So having insurance may cover for these, but insurance companies are great at denying claims. Anybody that's ever had a water claim knows the difference between a fast leak and a slow leak. Slow leak they don't pay for, fast leak they do. Slow leaks cause more damage than fast leaks. You don't know that until you make a claim. So how good is your insurance to cover you? And then lastly are acts of people I love and myself. I have children above 18, but they drive cars that I own. If they get in a car accident, that child's in trouble, and so am I because I own the car. So there's the possibility of an auto accident. There's the possibility my son was playing golf yesterday on a backswing. He almost hit somebody because the guy was teasing and ran up behind him. Should my son have known, and if he would have clocked him and hit him in the jaw, is that a liability? And then lastly, for me, for my friends that are entrepreneurs, we often give other people advice, and that if advice doesn't go well, they can sue us individually. So for all of life's happenings, including the sale, should I not protect my stuff from other people taking it away? I could make it again. I'm only 61, but I don't want to.
What about, so the topic is today, the protection continuum, or asset protection continuum, I should say. What is that?
So it's what I mentioned earlier of those different things. You kind of start out at the bottom with, you should homestead your home. There's a way your county recorders say, protect in California the first $175,000 of my assets. And then there's the idea of LLCs or corporations owning things for that, what I talked about, separate bucket theory. You should always consider insurance, property and casualty, et cetera. And then beyond that, you're probably reaching towards, how do I have trusts own things that are not my name? Not my revocable living trust, but an irrevocable trust that's considered a separate taxpayer ID number. So if I get sued, they can't get it. And I'm going to have to choose a jurisdiction that honors that. I live in California, not a jurisdiction that's nice to people have money. But I have assets in a Wyoming trust, Nevada trust. Both of those states are really good to people that have businesses, property, and money. So their laws are more leaning in that direction.
What are some potential issues and limitations associated with asset protection?
I have to be careful that I'm not transferring an asset to hinder or delay a known or foreseeable creditor. So if I was to do some planning today and transfer assets, and I don't know of any foreseeable creditors out there, I'm fine. But God forbid, if we use the example, my wife got a car accident, she's fine, but somebody else was not. If I transfer that asset after I got that phone call, that would be to hinder or delay a foreseeable creditor. And in doing so, the advisors that help me move the money are personally liable, and so am I. So it used to be the fraudulent conveyance statutes. Most states have developed what's called the voidable transaction statute that voids the transaction and pulls the money back. But depending on where I do it, each state has a different rule for each country. So although if I did do that, I moved it to Nevada and they didn't come and sue me, Wyoming, and they didn't come sue me for more than 120 days, the assets are already there. They could tell me that I should void the transaction. They could sue my advisors as well as me and win, but they wouldn't be able to get the asset because it was outside the reach of a California judge. And in Wyoming, that judge will say, you're trying to investigate a judgment that we've already protected against. You didn't come here fast enough because you didn't win fast enough. So therefore, you can't have the asset, and we're ordering the trustee to not give it to you. Now, litigating attorneys hate this conversation. And I have it all the time. I draw pictures. I say, here are all the assets that you're going to get to. Here are the assets you might get to. And here's all the rest that you won't get to. And I'll give you copies of everything. And they yell and scream and they say, you can't do that. And I said, but I do this for a living. I teach this.
Yeah.
So it causes a settlement, not that day because they yell and scream for their client. They get all upset. But a month later, when they realize what's happening, because they call the experts, who oddly enough are friends of mine or students of mine, who then say, well, if it had all this, you're in trouble. So it causes a settlement of the problem earlier. So lawsuits aren't about going away. Hardly less than 5% of all lawsuits go to litigation, go to court. It's about how does it settle? And how does it settle is about how you're structured.
And so as M&A advisors, we look at the business and the assets that, related to the sale and all that sort of stuff. What should we be doing to advise them? Is it, going over some things, bringing someone like yourself in to kind of be that wingman, like you mentioned previously? Like how should that dynamic work to make sure that they're protected?
I often, I teach a lot to the different trades. And it's the same advice. Whatever your center core competency is, you tend to revolve around the advice around that competency and how you get paid. If you are willing to bring into the conversation the other things that the client is concerned about or should be, you win the business. Because everybody else is talking about that thing, that transaction, that expertise, and how the advisor gets paid for it, and the net to the client. If you talk about the things to the left and the right, above and below it, the client says you've got all of what I'm looking for intact. For instance, it's not about the number I'm going to be bought for my business. It's about how much net do I get in my pocket, and what does that net in pocket generate for cash flow to replace the cash flow I have with the 4 motives I talked about. So the M advisor who speaks like that wins more business, and more business closes instead of dropping out at the last minute. So inviting people like us to that, I invite other advisors all the time, because it's in that team environment that you make sure the deal gets done.
Mm-hmm.
Way too many advisors try to exclude the other advisors to land the deal and move on, but they don't realize that's why so many deals get nixed and why they lose. They don't win business as much as they could. They're not closing. Their closing rate would increase to get the business if they discuss the things around what they're doing and they played well with others in the sandbox. And they would close more deals if they dealt with the problems that are going to come up later early.
Mm-hmm.
So more deals wouldn't fall out.
Yeah. Go ugly early, right? I mean, you gotta get that all up front.
God, yes. Because business owners are great at tackling problems that are foreseen when they get an idea to do it ahead of time. But a missed expectation, when a business owner says, "Why didn't you tell me that?" is not a good day in the neighborhood.
No, absolutely not. And I would imagine, as an M&A advisor, you especially if you're experienced, like all the things that could happen or that, could potentially go wrong. And to just, here's what it is. And this is what we got to think about. This is what we got to discuss, instead of addressing it as it comes up and delaying or inevitably causing the deal not to happen.
There's two schools of thought. Like you said, we make a good wingman to a lead advisor. We do best when there's somebody who wants to handle the client relationship, calls us in, has us do a task. We support the advisor, support the client. The client calls us direct. We make a joint call and honor that relationship. We talk to this advisor ahead of time about what we may be talking about or not, what we may advise or not, so they're not caught flat-footed. I don't want them to whisper ahead of time, but so we're even up where we're in.
Mm-hmm.
Some advisors would say bringing up these extraneous things takes away the focus of selling the business. And I'm going to say, yes, it takes away its focus, but it's going to be taken away at some point. Why not deal with it way up front so it doesn't derail the deal? I would rather lose 1 out of every 10 deals up front than lose half of all deals at the back.
Right.
If I get 10 and 1 out of 10 drop out up front, and out of the rest of 9 close, versus I get 10 and 5 drop out during the process for something unforeseen by the business owner, mm-hmm. I prefer 9 out of 10 versus 5 out of 10.
Mm-hmm. Absolutely. What is you say the 1 out of 10 up front that might kind of fall off or not? Like, what is that reason typically?
Well, because a business owner gets very excited because they received an unsolicited offer, let's say for $10 million.
Mm-hmm.
And they've never seen $2 million in one place at one time. So they go, "Oh my God, I could live the rest of my life on that." Well, wait a minute. $10 million. If they started the business and they live in a state that has an earned income on tax on that, and there's a capital gains tax, there's going to be a 40% tax. That's $6 million net.
Mm-hmm.
Oh, by the way, the buyer wanted me to carry 20% in paper. That's only $8 million up front. Minus $3 million of tax, that's $5 million net. Okay, $5 million net. I'm going to take and I'm going to pay off a couple of mortgages and things. I get a $4 million net. And that $4 million net is going to generate me, round numbers, $200,000 a year. Joe, I'm taking $500,000 a year now and it's not enough. So they're going to find out later. That same argument, I had 2 guys that sold a company, partners, that started with about $1 million of value apiece. They got a $100,000 unsolicited offer, $100 million unsolicited offer. I convinced him to get an M&A advisor. We ended up selling for 130. But in the 130, we had roughly $30 million of rollover stock to Newco. So 100 left. Out of the 100 left, they wanted to buy personal use assets. So it's 50 apiece. One of them said, no personal use assets. I'm capping my wife at the new house at $4 million. The rest is going to work. We did the math. He was fine. He was older. The younger one wanted to buy the vacation home at $3 million, the $1 million yacht, the $10 million home. By the time we were done, it was $15 million that went off the table. 35 left. Oh, there was taxes. Oh, wait a minute. On the money they got, there was a tax of $20 million that was due. The second guy ran out of money at this conversation. So we had to talk about what it does, how it performs. Personal use assets not only cost money out of production, but they cost money to run. So what can happen is that a business owner sees a big number, but doesn't realize the cash flows of it. And at the very end, they're talking to a CPA and an attorney, a CPA and a financial advisor, and they're finding out, and the spouse looks over and says, you mean my lifestyle is going to go down because you're selling? Or we're going to run out? What the hell plan is that? And then George puts his head down and says, I think I'm going back to work, and cancels everything for valid reasons, but we all know what it was. Mm-hmm. So dealing with that up front to dial in what's the number they really need and what's the cash flow and where they put it allows them to plan and say, yeah, I can sell, but I'll do these things. Mm-hmm. But once a business owner makes commitments, my mom, I'll pay off your home. Honey, I'll buy you the bigger home. I'll buy my parents' old ranch. Not knowing what the number net is and what the cash flow, I bought a farm because my mom was upset that the family farm in Iowa was going to be sold. It is a losing proposition. It's not going up in value much. I definitely lose money on this thing because the money that I bought it for deployed at very little would be earning more than it earns now. So it makes money, but not what it should. But it made my mom happy and not get her stressed. I'm in. But I made that knowing that the rest of the house could perform. But I had to sit down and do some math with my advisors to find the best way to do this.
Yeah.
Now, oddly enough, I'm taking a tax benefit that makes it worth it to me. But I would have done it for mom anyways.
Yeah.
How do you get a business owner to seek the right advice? And it's your M&A advisors that should be pulling the people at a table early to solve for the issue so the deal doesn't fall out.
Yeah. That's great advice. That's great advice. And what a great way to end our 3 episodes together, Joe. This has been amazing. You gave a lot of good insights into the great work that you do, how it can benefit our clients, which is what we're all in it for, right? Making sure that they're protected, they're prepped, they're ready to go, and they understand all the things that go into this, because a lot of times there could be stuff that they're not thinking of that we, as these professionals, need to bring to their attention during this process.
And if I could make the argument, great M&A advisors that do really well financially, within 5 years of deciding to collaborate well with others and take care of clients at this level, get so much referrals from their clients, they can't get to all the work. Mm-hmm. But it's about playing well in the sandbox with others and following up 1 month, 6 months, and a year later with those clients, checking in. And if something didn't go right, say to that client, I'm going to fix my process to do it, and getting screaming cheerleaders out there that are people selling businesses. Mm-hmm. Then you get to kill it.
I couldn't agree with you more, because you do good work. Like you said, you're a servant. If you're a servant to others, that'll ultimately in the long run come back and you'll benefit more from it. I couldn't agree with you more.
Blessings to all your people. I hope you all have a blast tomorrow when you're working with clients, for this year coming up when you're working with the clients, and you get a lot from Cornerstone. Thank you for including me.
Yeah, Joe, appreciate it. This is amazing. Everybody, make sure to check out Joe and all the great work that they're doing. We'll put all the links in the show notes so you can go and check out, all the stuff that they're doing, how you can work with them, how you can get educated by the great tools and resources that they have. Again, like, share, comment this episode. You can find all of our episodes at cornerstoneia.com/podcast. Thanks for listening, everybody. Until next time, take care.